The Supreme Court of India today refused to entertain a petition by Advocate Ashwini Kumar Upadhyay seeking uniform marriage age for men and women. As per the existing law, the minimum age of marriage for women is 18 years, whereas the minimum age of marriage is 21 years for men. Upadhyay today argued that the distinction between the age of marriage for men and women was arbitrary and violated Articles 14, 15 and 21 of the Constitution. He sought an increase in the age of marriage for women to 21 years, which would be at par with men. However, the bench comprising Chief Justice D.Y. Chandrachud, Justice P.S. Narasimha and Justice J.B. Pardiwala underscored that the court cannot issue a mandamus for the parliament to legislate and that any change in legislation should be left to the parliament. At the very outset of the hearing today, CJI D.Y. Chandrachud remarked, and I quote here, "You're saying that women's age for marriage should be 18, it should be 21. But if we strike down 18, there will be no age at all. Then even 5-year-olds could get married." However, Advocate Ashwini Upadhyay responded saying that the existing disparity in the age of marriage for women is arbitrary, and he also pointed out that a legislation to this effect has also been tabled in the parliament. Essentially, in 2021, the centre had introduced a bill in the parliament to raise the age of marriage for women as 21 years. The bill has been referred to a parliamentary standing committee and is currently pending. Accordingly, Justice P.S. Narasimha today questioned during the hearing, and I quote here, "If there is already a legislation being argued, then why are you here?" During the hearing today, the bench was also visibly miffed at some statements by Upadhyay. What irked the CJI was a comment made by Upadhyay. Upadhyay had questioned during the hearing, and I quote here, "What was the point of transferring this to Supreme Court?" The Supreme Court had transferred a similar petition pending in the Delhi High Court to the Supreme Court. Giving a firm response, CJI D.Y. Chandrachud said that Upadhyay need not offer gratuitous comments. Quoting from the CJI's oral observations in court today, "We are not here to hear your opinions. Fortunately, our legitimacy doesn't depend on what you feel about us. We don't want your gratuitous comments on what you feel about us. We are here to do our constitutional duty, not here to please you, nor are we here to please any polity. So don't you give us your gratuitous comments on how you feel for us. You're a member of the bar, argue before us. This is not a political forum." Accordingly, the Supreme Court today dismissed the petition and asked Upadhyay to not make a mockery of the jurisdiction conferred upon the Supreme Court under Article 32 of the Constitution. Emphasizing that deference must be shown to the Parliament, CJI Chandrachud remarked, and I quote again, "Mr. Upadhyay, don't make a mockery of Article 32. There are some matters which are reserved for the Parliament. We must defer to the Parliament. We can't enact law here. We should not perceive that we are the exclusive custodian of Constitution. Parliament is also a custodian." For more information on what transpired during the hearing today, you can refer to a detailed report, the link to which has been given in the description box below. Thank you. I'm Marital for LiveLaw. Keep watching LiveLaw for more such updates.